Right, good morning everybody. Nice to see good attendance again. It's a nice day, a little bit wet underfoot, but sadly that's the story for the last 8 months as far as I can see. So, yes, yeah, it's as a farmer it's been a bit of a damp season, but there you go. Right, could I have apologies please?
Yes, thank you, Chair. We've received apologies from Councillor Jill Waring. Thank you.
Thank you. And item... Someone's just going... All right. Okay, can you add another councillors to the attendance? Thank you. Jack Abrahams, obviously. Right, so anyone got any declarations of interest with what's on the agenda this morning? No? Okay. Can we therefore move on to item number 3, which is minutes of the meeting held on the 19th of January 2024. Moved, passed. Okay, everyone's happy with that. I will just sign them now and then it's done. Thank you. And item number 4, which is the Wildlife and Countryside Act 1981, an application for the addition of an alleged public footpath from Mill Lane to public footpath number 12, Kingston. Have we had any, before we start, any representation from local members?
None received, thank you, Chair.
Thank you. And I understand Laura's taking this one. Thank you.
Thank you, Chair, members. This is an application for an addition of a public footpath from Mill Lane to public footpath 12 in the parish of Kingston. The application is supported by historical evidence. The application route can be seen marked A to B on the plan attached to Appendix B. Comments have been received from the local member, and these are contained at Addendum 2 and referred to in the addendum to the report. Moving to the recommendation, that is, that the evidence is sufficient to show that a public footpath may be reasonably alleged to subsist on the route marked A to B on the plan attached. Turning to the historical evidence, the applicant submitted a deposited railway plan and account book and ordnance survey maps dated 1887 and 1901 in support of the application. The deposited railway plan for the Derby, Uttoxeter and Stafford Railway at Appendix C shows the alleged route in plot numbers 19, 21, 22, 23 and 27. The accompanying book of reference records the existence of a field and footpath within these plots, and these are recorded as being owned by Earl Talbot and Earl Ferriers and overseen by the Surveyor of Highways. It would suggest that Earl Talbot and Earl Ferriers were the owners of the soil in respect of these plots, and that the Surveyor of Highways was responsible for the maintenance of the highway, in this case a footpath, explained in the annotation from the account book. We have reference to the Surveyor of Highways that is almost certainly suggestive of a public right-of-way passing over the plots, showing the entirety of the application route. Clearly this annotation is good evidence that the route was indeed likely to be a public footpath. Railway plans and account books were produced by the railway companies and were necessary for major schemes of work. The surveyors compiled details of landowners and land holdings, which then formed part of the Act of Parliament. Recording highways may not have been their primary purpose, but they were typically included as a consequence of surveying the land. The Ordnance Survey maps, dated 1887 and 1901, both depict a parallel dashed line along the line of the application route, providing evidence that there was a route in existence on the ground. The Ordnance Survey plans can offer us a degree of clarity. Whilst they cannot clarify the status of the route, they can give us an indication of the extent of the route. The status is ratified by the evidence and description of the application route in the deposited railway plan. Officers have received no comments from landowners following consultation on the report. Landowner response forms were received from the landowners on the 1st of December, and these are attached at Addendum 1, and comments provided within the addendum to the report. Members will be aware that the wildlife and safety concerns along the application route must be disregarded under the law as it currently stands, and these concerns are not a matter of this tribunal of fact. If the application were to be successful, then our colleagues in the Rights of Way Department will be able to advise on how these concerns could be mitigated. The local councillor commented on the report, and these comments and officers' responses can be seen at Addendum 2. The fact that the proposed application route has not been walked and is not currently in use holds no relevance to the claim, as it is based on historical evidence. The legal maxim is once a highway, always a highway, and therefore this means that a public right-of-way does not cease to exist, even if no one uses it. The application is made under Section 53, 3CI of the Wildlife and Countryside Act 1981. Therefore, there are two tests to be considered. That of the balance of probabilities, whether the route subsists, or reasonable allegation, whether it can be reasonably alleged that the route subsists. In conclusion, the evidence from the deposited railway plan and the reference to the surveyor of highways and the ordnance survey maps provides sufficient evidence for the lower test of reasonable allegation that the alleged route is a public right-of-way with the status of a public footpath. There is no evidence of higher rights along the route or that the way has been extinguished or stopped up. As such, it is officers' recommendation that the application be accepted and that an order be made to add the route as a public footpath to the definitive mapping statement for the Borough of East Staffordshire. Your officers further recommend that this should be to the minimum width of 1.5 metres throughout its length. Thank you. I'm happy to take any questions.
Thank you, Laura. I think we were misinformed slightly about no representation from local member, because it is in the report. And I will just refer to that because obviously if a local member said it, it's fairly important. Do you mind if I quickly read it out? Dear Laura, apologies for last minute comment. This is from Philip Atkins, who's the local member. I'm worried about the strength of a map drawn up in 1845 and 1846 as a reference to the footpath, as this would serve no useful purpose as far as I see in 1845, 1881 or today. I believe it should go to the Crow panel to test the validity of the claim on 2 points. One, how can we validate a map almost 200 years old on a footway that would serve no useful purpose as far as I can see in 1845, let alone today? And the second point was, also, as the OS maps in your report states, from the early 1880s, the map includes a disclaimer to the effect that the depiction of any path, track or way was not evidence or evidence of public rights of way. And I also noticed in the landowner's responses, one of them did actually say that there was evidence of a footpath on an old map. So we've got slightly conflicting evidence here. Just for clarity, could you just answer those 2 points before we open it up to members?
Yes, certainly. So in connection with the Ordnance Survey maps, as I've stated within the response to the councillor as well, they can't offer they can't clarify the status of a route. However, they do depict the line of the route on the ground at the time. Throughout its extent, it's the deposited railway account book that would suggest that the route is a public route, and the Ordnance Survey plan confirms that the route was on the ground at the time.
That's it. That answers the 2 points. Paul.
Thank you, Chair. Thank you, Laura. Ordnance Survey maps was basically written for the army, so they could march their troops and know what the level of the land was. That was what all that was about. Philip's had a good go, but he should come to Crow Panel and watch what we do a bit more often. But really, I think it's made out, as you said in there, once a footpath, always a footpath. The surveyors, if they got it wrong, they went to prison for fraud. So when they did it, they normally got it right historically. And as you say, the landowner even admits that there's the probability there's a footpath there. So really, on all the evidence that's put there, the railway plan, the Ordnance Survey maps, the survey of highways in his book, the evidence is there. And even if we don't get balanced probability, we go the lower of reasonable allegation. it is made out. So I will propose that we move forward with this and that it is put on the definitive map as a public footpath, a minimum of 1.5 metres.
Thank you. David?
I'm happy to second that, Chairman.
Thank you. Go vote on it then. All those in favour of the officer's recommendation? Okay. Well, I think David seconded it, so he must do. Laura, thank you. We'll go with your recommendation. Okay, and moving on, please, to item number 5, which is Wildlife and Countryside Act 1981, an application to upgrade public footpath 56. Is it Cotton or Coton? Cotton.
Cotton, I believe, yeah, in the report.
An application to upgrade public footpath 56 Cotton to a Coton. I knew it would cause problems. To a public bridleway in the parish of Coton. Okay, thank you. Hannah, I understand you're taking this one.
Yes, thank you, Chair, members of the panel. So as stated, this is an application to upgrade public footpath 56, Coton, to a public bridleway. The application was submitted by Staffordshire Moorlands Bridleways Group, and it was submitted based on historical evidence. The original evidence submitted consisted of an Alton and Bradley in the Moors enclosure award dated 1833, a copy of the statement accompanying the definitive map, and copies of various old maps. So if we turn to the evidence to begin with, starting with the enclosure award. So enclosure awards were designed to enclose land to increase agricultural productivity. On review of the enclosure awards, there is a route depicted running along the same line as the alleged route, and it is referred to as Coton Green Road. The 1801 General Enclosure Act standardised the clauses used in enclosure acts. This award refers to the 1801 Act. The preamble to the award sets out that the enclosure commissioners had the powers to set out, create and divert routes. Coton Green Road is depicted on the map as a minor carriageway, and it is uncoloured. In the award, Coton Green Road comes under the section Occupation Roads. This would therefore suggest that the route would not be used by members of the public at large, because the term Occupation Road was typically used to describe a route that was used for the benefit of occupiers or adjoining properties, and therefore not to be used widely as a public highway. Occupation roads were often constructed as a result of enclosure acts and were designed to provide access for landowners to their allotments. This is supported by the text of the award, which states that the road is for the use of the owners and occupiers of estates in the township of Coton, and the road would be kept in repair by the occupiers of the adjoining lands out of number 131. So this would suggest that the road was to be used by people living within the adjoining land in town, and it was not considered necessarily to be a public highway for the public at large, as the public were not to take on maintenance responsibilities for the route, again therefore suggesting that the route was private and not a public highway. The fact that the route is referred to as an occupation road would suggest that it may have been capable of being used by carts and carriages and also people on horseback, but it's more likely that these rights would have been private rather than public. When we consider the Ordnance Survey map dated 1986, this map shows a route running along the same line as the alleged route. It appears to be a broken single line. There is no key with the map, so nothing to indicate the status of the route or the nature of any rights over the route. When we consider the other maps submitted with the application, we have a map that is recorded as showing a way other than a footpath. This map shows a route running along the same line as the alleged route as two solid lines, although it is not depicted as a main carriageway. The map also shows several routes with the annotation FP. The alleged route is not depicted in the same way as those routes with the annotation FP running alongside them. This would suggest that the route was not classified as a footpath. However, there is nothing to indicate the actual status of the route or the nature of any rights over the alleged route. With regards to the map recorded as map showing way marked as a RUP, the map shows the alleged route marked number 56 and running along the same line as the alleged route. Similarly to the other map, there are several routes shown as single dotted lines with the annotation FP alongside them. There is no annotation along the alleged route, and it is not depicted in the same way as the routes with the annotation of FP alongside them. The route is depicted as two solid lines with a black single line with arrow symbols running along it. This supports the route status as a road used as a public path. As the map depicts the route as a RUP, it supports the route being capable of being used by vehicles, but that it was most likely to have been used by the public on foot or horseback. When we consider the statement accompanying the draft definitive map, the statement accompanying the map refers to the alleged route as a RUP, a road used as a public path. So again, this supports that the route could be used by the public with vehicles, but it was mainly used by the public on foot and horseback. When we consider the definitive map and parish survey evidence, the 1968 Countryside Act stated that all routes classified as RUPs should be reclassified either as a footpath, a bridle way or a byway open to all traffic. As a result of the review brought about by the 1968 Act, Path 56 must have been reclassified as a footpath. It would appear that no objections were raised to the reclassification of the route during the first and special review. Officers have obtained a copy of the parish survey card for public footpath 56 Coton, which refers to the route as a RUP. The fact that the route is referred to a RUP and a road shows that the route was capable of being used by vehicles, but that it was most likely to have been used by people on foot and horseback. The description in the card does not provide much information regarding the legal rights over the route, and evidently this is not a strong piece of evidence on its own. The description given of the route may just be a description rather than describing the rights over the route. The fact that a route was once classified as a RUP also does not automatically mean that the route has bridle rights over it. All available evidence needs to be considered to ascertain the exact nature of any rights over an alleged route. Officers also reviewed an Alton tithe map which shows the northern section of the route but not the entirety of the route. The route is depicted as two broken lines and then the route forms part of plot 580. On review of the award, plot 580 is referred to as common piece and/or lane. The term lane is generic and provides no information regarding the nature of any rights over a route. So therefore there is nothing to indicate whether this section of the route depicted in the award is public or private, and therefore in relation to the entirety of the route, the evidence is relatively weak. Evidence has been submitted by landowners. Landowner 1 responded to the application, advising that they object to the application and they consider the route to be a footpath only. They also raised safety concerns. Landowner 2 has also advised that they consider the route to be a footpath only. They too have raised safety concerns and raised concerns about the impact of an upgrade on livestock that graze the land. Evidence has also been provided by Coton Parish Council. They have also responded objecting to the application. Again, they have raised concerns about safety and the cost of work to make the route fit for purpose for use as a bridle way. Whilst it's not our intention to belittle any legitimate concerns raised, the courts have decided that issues relating to safety, security, privacy, suitability, future maintenance, and wildlife concerns cannot be taken into consideration. Only evidence regarding the existence or not of a public right-of-way can be taken into consideration. In addition, the British Horse Society, the Ramblers Association, the Pecan Northern Footpath Society, the Open Spaces Society and the Byways and Bridleways Trust all responded to the application, confirming that they support it. So when we consider the relevant legal tests to be applied in this application, what is not in dispute is the fact that the route is a public highway. The question relates to the status and nature of the public rights over the route. Therefore, the evidence needs to be considered on the balance of probabilities as to whether the evidence shows the existence of a public bridle way along the line of the alleged route, and therefore that the current classification of the route as a footpath is wrong. So to summarise, the enclosure award evidence is suggestive of private rights rather than public rights and provides no clear indication of any public rights of any specific nature in relation to the alleged route. When considering the other evidence is evidentially less strong and again doesn't provide on the balance of probabilities that the alleged route has existed as a public bridle way. Therefore, to conclude, when all the documentation is reviewed together, it does not support the contention on the balance of probabilities that the route should be reclassified as a public bridle way. Therefore, Officer's recommendation is to reject the application and for no order to be made to upgrade the route to a public bridle way. Thank you, and I'm happy to answer any questions.
Thank you. That's an interesting report, and it is all about sort of that fine balance. Just to sort of clarify, reading the report, it did say that the Bridleways Association, Ramblers and such like, none of them had any evidence, but they supported it. I think that's slightly different than it is. Members, start with Jack, please.
Thank you very much, Mr. Chairman, and thank you for the report. It's very interesting, this one. I think although it's a slightly controversial in terms of both sides wanting their part, I'm happy to go with the officer's recommendation. Thank you. It is, yeah.
There's a lot of stated cases in there, which makes it even more interesting, isn't there? Yeah. But really, if you go with like the two at the end, Kind and Riley, where it says we mustn't assume things have happened and stuff, I think we've got to go with officer's recommendation on there, really, because there's no real evidence to say that it was anything but a footpath before, and that's what's been argued there, I think, by yourselves. So unless they can prove there was anything more than a footpath before, then we can't go against what the decision was. So I think really I've got to go along with Jack's proposal and second it and say that it should remain as a footpath.
Any other comments? Okay, so we'll take a vote on it then. All those in favour of officer's recommendation? I think that's unanimous. Thank you very much for both reports. And we've got no exclusions of the public, so we'll close the meeting at 10:23. And thank you all for attending. And thank you to, is it Dan? Your son's at the back watching what's going on. Yeah, your grandson. Thank you for attending, and I hope you enjoyed it. And we'll close the meeting. Thank you all very much.